Good evening, folks. We'll call this May 2nd, 2017 special meeting to order. The purpose of this meeting, our agenda, is one item only, is a quasi-judicial public hearing, ordinance 2017-LDR 17-02, an application by George F. Young, Inc., agent for Michael L. Steinberg, owner, requesting approval of a development agreement for the Dillons Grove Planned Rural Residential Development Phase 2. The project is approximately 131 plus acres containing 29 lots, lots 19 through 47. Mr. Attorney, should we read the quasi-judicial at this point?
Yes, sir.
And do we just have the applicant in presence tonight?
So far.
All right. All right. This procedure is to ensure that the applicant provides a complete presentation of their request prior to any testimony being provided by the staff. All public testimony will be taken under oath. Everyone testifying will be subject to cross-examination. All documents and exhibits shall be entered into evidence. The giving of opinion testimony is limited to experts, and closing arguments will be limited to the evidence of record. The procedure we will follow this evening is that we will first hear from the applicant with no time limit. Then the applicant will be subject to cross-examination. The staff will then enter the staff report into the record and answer questions. The applicant will have the opportunity for rebuttal of any testimony against the application. The floor will be open for public comment. Those presentations will be limited to 5 minutes. Members of the public will have an opportunity to question the applicant or staff. The applicant will have an opportunity for closing arguments. The public hearing will be closed, and the commission will enter into deliberations. At this time, if you intend to give any testimony tonight, will you please stand, and Ms. Judy, will you administer the oath, please?
Please raise your right hand, and if you'll state your name one at a time, then I will administer the oath.
David Depew.
Patrice Boys.
Bryan Thomas. Stuart Cullen.
Do you hereby swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I do.
Okay. When you come up to the podium, if you'll state your name again and state that you've been duly sworn.
Mr. Attorney, would you like to ask for any ex parte communications at this point in time?
That would be fine, Mr. Mayor. At this stage, if there are any communications that any of the commissioners have had that we call ex parte discussions, and what I mean by that is discussions that are outside the purview of this meeting tonight. If you've talked to anyone on the applicant's side, anyone on that has some concern with relation to this development, then if you would put that on the table now, and then if somebody wants to ask you about that communication as to whether or not it affects your deliberations this evening, then certainly that person or that individual can ask that. So if any of the commissioners have had such discussions, you should talk about that now.
Commissioner Coleman? Commissioner Farnsworth? Commissioner Glanzer?
Before I got elected and after when I was on the zoning board, I had a brief conversation with Ms. Boyce, acknowledging that she was representing Dillons Grove, but I had no conversation about the actual issue.
Did the conversation revolve around Dillons Grove?
No.
And there's nothing that was said at that discussion that would lead you to change or bias your opinion this evening?
No.
And of course, you sat on the Planning and Zoning Board, but that's of record, and you received testimony at that time and
It's very familiar.
Right. Okay.
Thank you.
Thank you, Commissioner Glanzer.
And I did not have any ex parte communications either. All right. Are we ready to hear from the applicant?
Yes, Mr. Mayor. That's fine.
Okay.
Good evening, Mr. Mayor, Commissioners. My name is Patrice Boys. I've been duly sworn, although I don't give evidence, I give you argument. But in the abundance of caution, I was sworn. I do represent Michael Steinberg, who's the applicant for approval of the next phase of Dillons Grove. And we do appreciate the special meeting this evening and you taking the time to allow us to give you some additional context for the application. Dillons Grove is, as you know, a high-end development first approved by the city in 2002 when the PRRD zoning was approved at the request of both my client and his then wife. The PRRD allowed a maximum of 70 units. 18 lots were then platted in Phase 1 under its own development agreement in 2004. That leaves a balance of 52 lots to plat on lands that have been marked for residential development by the PRRD. At the last hearing, you learned that the ownership of the rest of the land outside Phase 1 was divided by court order in November of 2011, giving my client 56% of the land marked for residential development and 44% of it to his ex-wife. Logically then, 56% of 52 lots is 29, 44% of 52 lots is 23. Simply put, the application before you is to approve the next phase, which is 29 lots. A typical development agreement is before you for approval this evening. You've seen this template many times. It covers the details of this new phase of development to ensure that it remains consistent with the PRRD, the Unified Plan of Development for all of Dillon's Grove, and the existing development order, which is still in full force and effect. The construction plans and the plat will come back to you at a subsequent meeting for approval. Very careful consideration has been given this application by our consultants. All of the city's requirements have been met, in my opinion, and an approval, importantly, an approval by you this evening would not prejudice any owners of land or platted lots in Dillon's Grove, including the homeowners in Phase 1. In fact, we believe approval should enhance property values, the city's tax base, and the desirability of the remaining property for development. In conclusion, we request your favorable vote this evening on the application for the development agreement. I have several exhibits I'll identify for the record and provide them to the clerk. The court order dated November 21st, 2011, that's our starting point, and shows you the split. A summary of the appraisal that was done in support of that order that shows the value of the property, so you can track how that went. I think I mentioned at the last hearing that my client attempted to have the court revisit the land split through a motion. So I have a copy of that motion for your record and the order denying it. And I understand the staff report will be marked into evidence as well. Next, I'd like to introduce Dr. David Depew, who is an expert in comprehensive planning, zoning, and development regulations. And as part of the exhibits for your record, I'll provide a copy of his CV, his report, and a hard copy of the PowerPoint he's going to show you. Thank you. So Mr. Mayor, with your permission, I'll approach the clerk with those exhibits.
Absolutely.
Good evening. Good evening, Commissioners. My name is David Depew. I am a land planner and principal with the firm of Morris Depew Associates. We have our primary office in Fort Myers, but we also have offices in Tallahassee and in Destin. We used to have an office in Newberry.
I have to get you back.
Well, I'm glad to be back. It's been a few years, and I have to tell you, you're all new except for Mr. Walker. I'm sure he didn't really want to hear that. At any rate, I have a doctorate in public administration. I'm a member of the American Institute of Certified Planners and have been a member of that institute since 1983, a member of the Florida Planning and Zoning Association, a member of the Real Estate Investment Society, a member of the Institute for Transportation Engineering. I'm sure there's some other Urban Land Institute. There's probably a bunch more. I have been a land planner in the state of Florida since 1980. And I have been certified as an expert in planning, zoning, and a variety of related issues, including transportation planning, over the years. I've never been in a situation where my testimony has been either stricken or disallowed for purposes of expertise. So I'm here today as a part of a request that you are reviewing. When I was contacted by Ms. Boyce, what she really wanted me to do was take a look at the request in order to provide some background and an independent analysis as to what exactly was going on and what my perception was in terms of how we approach this. And I will tell you that's exactly what I did. I didn't look at it from the standpoint of how do we get this approved, how do we go from here to there. What I did was I tried to look at this from the standpoint of here's the request that you're considering, here's the regulations that are before you, here's the unique circumstances associated with the request, how do they fit together. I think you all know what property we're talking about. That's a map of the ownership, and it's marked as to who owns what in terms of the property itself. That's part of a plat map from the Alachua County Appraiser's Office. It's a little bit more interesting, I think, to look at the aerial photograph that shows you what's out there now. And again, I know you all are familiar with this, but it does show you, I think, of interest, the fact that a portion of the property is developed, phase one. And that's what's in the yellow outline. The entirety of the property is in red. And that has a series of, as Ms. Boyce has said, 18 lots. You've also got the area that's owned by Ms. Steinberg, which is kind of in pink or purple. It looks a little purple because it's kind of overlain with the blue that abuts it, which is Mr. Steinberg's ownership. And you see the parcels are separate. You've got a chunk that Mr. Steinberg owns that's over just south of phase one, and then you've got another chunk that he owns that's to the west of phase one and then to the southwest of phase one. And then the little triangle he's gotten to provide access. Oh, that's fine. I mean, you guys know this.
Well, I think we do, but just in case you.
Thank you. So, I mean, this is phase one, and this is a piece that Mr. Steinberg owns. This is the other piece that Mr. Steinberg owns over here, and this is the piece that Ms. Steinberg owns. So it's an interesting aspect because what we've got here is a plan development that when it went through the process was characterized by unified control and unified ownership. But like most projects, as they develop and as they evolve, that unified ownership no longer exists. But the unified control still exists, and it exists by virtue of your regulations and what you've done to approve the planned residential rural development, the PRRD, that exists covering the subject property. So what I did was take a look at the background on this request. It's a total of about 352, almost 353 acres, approved originally in December of 2002 via Ordinance 03-02. As part of 0302, the city adopted the development order, which was 02-1, that controls how development is going to take place on the site. A 10-year development agreement was also adopted, which ultimately has expired. But part of what is before you today is to re-up that. And that is consistent with the state statutes that are controlling of development agreements with local governments and with private interests. So the re-upping of that is certainly within the confines of what is anticipated by the statute. The statute has a 30-year limit on these development agreements. So certainly whether it's an extension of the original one or whether it's a new one, you have the authority and the power to do that in accordance with the statutes. At the time the application was deemed to have met all the various requirements for approval, and ultimately what was approved was 70 lots, with the average lot size pursuant to the development order of 3.03 acres. Okay, so we've got 4 homes out there that are completed and 1 that's under construction. The density, in accordance with your regulations, is the total number of units divided by the total number of acres. So it would be the 70 units divided by, or the 352.7 acres divided by the 70 units, which is how you get the 3.03 acres per lot. What you've got before you is nothing that's particularly unique. It's a request for modification of the phased approval. First phase, as you could see from the aerial photographs, already constructed. And if I go back one, you'll see it's all there. I mean, the road's in, and you're going to see some pictures as we go through here that show you the amenity center, and there's 4 lots that have houses on them and 1 that's under construction. So that phase is done. But in keeping with virtually any type of development that occurs, in phases like this, as the development moves forward, the phases can sometimes change. Circumstances change. The market changes. In this particular instance, what changed was the ownership pattern. But it's normal. The ownership pattern typically changes on these sorts of developments. And even if it's just a matter of sale of the lots in phase one, the ownership pattern changes. So wisely, your regulations, consistent with, and it's a little bit chopped off there, but consistent with the way this is determined and interpreted throughout this profession in the planning universe, as it were, unified control relates to unified operation and common control. It does not relate to common ownership. You always, and in fact, even for the initial application, you could have had multiple owners as long as they all signed on for unified control. That's what the PRRD at this point does. It's adopted. It is the land use regulations that control that particular piece of property, regardless of ownership. The ownership is now taken out of it, and any individual owner can apply for changes for their particular piece of property, and as a jurisdiction, you evaluate that request to determine whether or not what you're doing to that piece of property somehow has an impact on any of the other elements of the PRRD or on your regulations at large. In this particular instance, I would tell you that from a professional standpoint, my analysis is that the impact is at least constant in the sense that it doesn't do anything, or positive to the remaining undeveloped portions of the project. So I would tell you from my standpoint and a review of the application and the regulations, the zoning designation runs with the land, not with a specific owner. Each owner has the ability to request these changes as need be. As Ms. Boyce indicated, the court decree divided up a portion of the remainder ownership for phase 2 and phase 3. If you start doing the calculation, 56% of the undeveloped residential area was awarded to Mr. Steinberg. That amounts to 78.94 acres, with 44% of the undeveloped residential area awarded to Mrs. Steinberg, 62.06 acres. 18 lots had been developed. 70 minus 18 equals 52 undeveloped but approved lots. 56% of the 52 lots equals 29 lots. 44% of the 52 lots equals 23 lots. The development plan that is before you tonight apportions the remainder of the undeveloped residential area in the exact fashion that the court decree undertook that particular split. Now, I mentioned it because there has been a lot of discussion about it. Your regulations don't mention this at all as a matter of consideration. Your regulations, in terms of what you consider, talk about what the development is going to look like, and are silent totally and completely with regard to who owns what. And that's because the land use runs with the land. That's because the land use runs with the land. The land use does not run with owners. I'm going to check just to make sure mine's off too.
Always a good idea, right?
So the court action didn't change the zoning. The property is still zoned PRRD pursuant to the adopted resolutions and development orders. The entirety of the property remains conforming. There are no non-conforming elements to the property, and the amendment that's before you tonight does not create any non-conformities on the property. So it proceeds pursuant to the existing and in-force PRRD approval in accordance with the regulations that you've got for modifying these PRRDs and any other kinds of approval that you have in the city. And all the owners have the ability to pursue this kind of amendment. So if Ms. Steinberg decides she wants to pursue it, you may see another request in front of you amending her layout on her site. The reason is because when the judge divided it, he divided it in accordance with the property boundaries that are shown in the property appraisers and looking at the residential area that had been undeveloped. And that's where you get the 56 and the 44% and the 29 and the 23 lots. And it it wasn't divided based on design. So in order to develop her stuff, she may be back in front of you with a change in design, again, pursuant to what the city regulations are. All the owners have a reasonable, economically beneficial use of their property. That was already determined with the original approval, and none of that has changed. The city is under no obligation to repeal any kind of overall development plan or sever that plan as long as each owner is available and able to develop pursuant to the PRRD approval. And again, just because the ownership was split does not mean that the PRRD has been somehow broken. The PRRD is independent of ownership, and the unified control document that was adopted as part of the original approval still fits. It still applies to the entirety of the development, and it would take positive action by you as a city commission in order to change that. Now, having said that, a judge could probably do something like that if the issue was in front of him. But that wasn't part of the issue with the divorce and the settlement agreement. There was nothing mentioned about the zoning in that settlement agreement. So when you look at it, you'll see there's nothing about the zoning. There's just stuff about who owns what. Finally, and this is the end here, but I'll be available obviously for any questions, and I'm going to talk just briefly about the conditions when we get to that stage. The Dillon's Grove development remains zoned pursuant to 0302 and Development Order 02-1. Mr. Steinberg has the ability, just as any owner, to seek an approval for his portions of the Dillon's Grove development pursuant to the city's adopted land development regulations in accordance with the original approval that has been granted for the PRRD. As I said, the 56%, 44% split is the exact 29 lot versus 23 lot split, and that 29 lots are in front of you as a city commission at this point. There's been no evidence presented at any point that I've been privy to, and I've looked through all of the files that were available on this, that would suggest any owner has been deprived of a reasonable, economically beneficial use of their property. Proper notice was provided. Public input was received on all of these matters, and in reviewing the application, my professional belief is that Mr. Steinberg has made a proper application for the approval of the remaining undeveloped lands in the Dillon's Grove development. One brief note here I would also tell you is that the applicant is fully in support of the 5 conditions that are listed on page 6 of the staff report. Although I would caveat that just slightly by telling you that we think some of the wording in the conditions are a little imprecise, and we would like to suggest that we would be able to tweak the wording in a couple of the conditions to bring that back to you at the second reading. For example, the way the wording is done on condition number 3, it talks about roads eventually continuing to future phases, paved to the boundary of such future phases. We would like the chance to actually talk about very specifically which roads are going where, because there are some roads at this point that we think are probably not going to be usable for future phases, where the others are. The other question about this is whether a roadway that is going to be just constructed and allowed to sit there for however number of years before the future development is done, it would make sense to build that now, or whether it would make more sense to bond it and build it later when it's actually needed so that it doesn't sit out there and deteriorate. I've had quite a bit of experience in dealing with deteriorating roads. When I was Community Development Director for Lee County, we had hundreds of miles of roads out in Lehigh Acres that just sat for years and years, and I'll tell you what happens is the asphalt cracks and you get grass growing up among it, and it wrecks the surface of the road. So we'd like the chance to come back and tweak the language on that one a little bit. We also would like the chance to tweak the language on number 5 just a little bit, because we want to make sure that that triangle is actually annexed, but we also know that we have to deal with Alachua County when we're dealing with annexation issues, and sometimes, I guess most tactfully, is that Alachua County can be a challenge to deal with occasionally. So
we've heard that from time to time.
So at any rate, we would like the chance to just tweak the language just a little bit. But again, in general, we have no opposition whatsoever to those conditions, and we're fully in agreement with those conditions. I am available for any questions that you might have.
Can I ask you one question
Yes,
before
sir.
I open it up to the commission? On the third item about the roads, you're not objecting to the principle that the
No.
roads should connect, that
Yes.
connectivity should be maintained.
Right.
Have you come across anything in your study of this issue that would preclude anybody building in future phases that would prevent connectivity, prevent access to that opening gate, prevent, I don't know, is this a clicked gate? I mean, so if
I have
another
not,
owner opens,
no.
begins
I-
to develop, will those owners be able to get clickers to get into the gate? And
Yeah.
those kinds of issues have all been, you would.
They're already part of the
your expert
homeowners
opinion would say
association,
that's
so-
a homeowner association.
Yes,
that
sir. Yes, sir.
There's no
They're
going to be
part
an
of that
issue there.
association. They have all the rights and responsibilities that come with that ownership. So I don't, at this point, I don't see that as an issue. But in any event, it's just the language on that I think it would make sense if the city accepted a bond or a letter of credit so that the money's there to build it, so that it's not a burden on the homeowners association or anybody else. But when it's necessary to be built, they got a brand new road, as opposed to a 5-year-old road or a 10-year-old road or whatever it's going to be. Because then the clock should start ticking on the wear and tear on the road, as opposed to just letting it sit there for years and years. And it does get worn,
Sure.
even in without traffic on it. So.
All right. Does anyone on the commission have any questions? Okay, hearing none. Does the applicant have any other parts to the presentation?
We'll be here for any questions or comments or anything you'd like to discuss.
Okay, thank you,
Thank you.
sir. All right, would staff like to enter in the staff report?
If there's any, Mr. Mayor, we had planned on a presentation from Ms. Steinberg. I don't see anybody in the audience, but there had been legal representatives prior to this meeting who had been here on behalf of Ms. Steinberg. So for the record, we're opening it up at this stage to Ms. Steinberg, but we do not see anybody here that wishes to testify on her behalf. So that will leave it to staff at this stage.
Thank you for reading that into the record. I skipped it because of the absence. Mr. Thomas.
Thank you, Mr. Mayor. My name is Bryan Thomas. I'm the Planning and Economic Development Director for the City of Newberry, and I have been sworn. A lot of what I'm about to cover is going to now be reiteration, but it bears repeating in a lot of instances.
I'm glad that was
Is there a problem with the
We're having a little bit of a technical glitch.
Well, I'm sure you have this memorized, Brian. Why don't you just start working from memory? I'm kidding, obviously.
I probably could do just that.
I've heard it 3 times.
As I said, we covered a lot of the same ground. Give it one more minute and then we'll proceed without it. Backwards? Not transitions. There we go. Okay, let's try one more time here. All right, so brief history. In 2002, the entire 352.7 acres of what was ultimately to become Dillon's Grove was rezoned from City of Newberry agriculture to a planned rural residential development. The governing ordinances are Ordinance 30-02, Development Order 02-1, and the Preliminary Master Plan, which were adopted as the permanent governing documents for Dillon's Grove development as part of Ordinance 30-02. 2004, there was an additional development agreement entered into between the city and Prestige Properties Incorporated, and specifically, personally, Michael and Miriam Steinberg. As previously mentioned, that development agreement had expired in 2014. After the ordinance was passed, Dillon's Grove Phase 1 was developed. 18 lots, approximately 78 acres. In 2011, Prestige Properties, Inc., owners Michael and Miriam Steinberg divorced. As part of the final judgment for dissolution of marriage, Michael Steinberg was awarded approximately 134 acres, and Miriam Steinberg awarded 139 acres of undeveloped portions of Dillon's Grove. In 2012, Miriam Steinberg had been awarded Prestige Properties, Inc. It was voluntarily dissolved in 2012. And the final judgment in dissolution of marriage does not speak in any way towards the land use issues that have been raised. It was very strictly division of assets in the dissolution of marriage. There was absolutely no mention of land use considerations. Brief description of planned rural residential developments. The concept behind a planned rural residential development is that it allows for residential development at the rural density of 1 unit per 5 acres, but it's meant to be a harmonious development that complements the surrounding rural agricultural area that it's developed in. Like all planned developments, whether it's a planned rural residential development, a planned development which is mixed use where you have commercial as well as residential components, or whether it's strictly a planned residential development, a planned development is basically a separate unique zoning district. It is a zoning bubble unto itself. It's governed by its own specific set of rules which are passed by ordinance, development order, and the preliminary master plan. And so once those documents are approved or adopted, they become the law of the land for that particular development. One of the unique characteristics of the PRRD, as was discussed, there's a 30% minimum undeveloped area which is a set aside for future more urban density developments. Basically, at such a time in the future when municipal water and wastewater services become available to the development, that undeveloped area set aside then can be redeveloped at the higher urban densities. And so it basically becomes a land bank until such a time as water and sewer municipal services are available. During the course of that period, until that land bank is developed, the overall PRRD will maintain an rural density of 1 unit per 5 acres. And so we move to the current application. Mr. Steinberg has applied for a development agreement which would govern the specifics of the development for revised Phase 2. We've been working with Mr. Steinberg for quite some time on this project. And the reason it took a while was because our primary concern was that through rigorous analysis he could demonstrate, his engineer and attorney could demonstrate that the property rights that existed on the separate parcels prior to the dissolution of marriage were maintained in the proposed plan that's brought forward. And so we believe that they have done a very good job of demonstrating that. We think that it does not grant any preference to either party ultimately, that they can develop after this plan what they could have developed if they were developing together originally. Staff considers this to be a revised plan to constitute a minor change in the preliminary master plan as opposed to a major change. And the reason that becomes relevant is in the PRRD code defines examples, it gives examples of a major change versus a minor change. And the reason we consider this to be a minor change is that a major change is a perimeter change, major street location, which major streets actually would be potentially streets outside of the development, arterial roadways and such, not interior local roads. And then change in building heights, densities, or land use pattern buffers, none of which apply to the application before you. Minor changes in the code are outlined as changes in alignment, location, or length of a local street, which we do have some of that, and adjustments or minor changes in dwelling unit mixes not resulting in increased overall density, which again, the overall density is going to maintain at 1 to 5 acres. And so that's, for that reason, staff does consider this to be a minor change. And so, back to the preliminary master plan. This is the preliminary master plan that was passed, approved in 2002. As we've discussed, the Phase 1 was developed jointly. After the dissolution of marriage based on existing property lines, Mr. Steinberg was granted these properties and then picked up this additional triangle piece to provide connectivity between those two parcels, and then the remainder was granted to Miriam Steinberg. What I wanted to point out here is that it's a little hard to read, but you can see in all of these parcels that were awarded to Mr. Steinberg, they're marked either residential or common open space, or of course road right-of-way. So he was awarded parts of Phase 2, parts of Phase 3. Miriam Steinberg was also awarded all of this area is residential, this area is residential, and then some common open space area as well. She was also awarded the totality of the land bank, the undeveloped area set aside, which is identified as Phase 4. And so, given that both parcels are roughly equal in overall size, and given that the totality of what was granted to Mr. Steinberg lies in either residential or common area open space, with none of the undeveloped space in it, logically you would expect that there's going to be at least a little bit of a difference in the overall development potential for these two parcels. And so, and if you look at the revised Phase 2 that's before you, basically it's all stays residential or common area open space. The property and ownership by Mrs. Steinberg is not touched at all. There's no revision of that as yet. It does provide for connectivity across this portion here. This roadway was reworked to provide connectivity up here because Mr. Steinberg would not be allowed necessarily access to build roadways across property he didn't own. When Mr. Depew discussed rewording the third item in staff recommendations, part of that would be this right here. What you have before you is only the application for the development agreement that allows Phase 2 to go forward. If the development agreement application is successful and it is allowed to move forward, then there will be a subsequent application for the construction plans and the plat. In the preliminary, or in the plat that's been presented, that you will eventually see if this is successful, the frontage for all of the residential lots runs along this line right here, this roadway. This would actually be a side lot access, providing access into the third phase. Given that under this scenario, you've got roadway connectivity in two separate points, this basically becomes superfluous. You could have road frontage to this residential area based on a cul-de-sac at the end of this road right here. This connectivity is no longer as considered necessary, really, because you've got multiple points of connectivity between the two parcels. And so that might be an area where there could be some adjustment, as an example. So staff would, I guess what I'm getting at is staff wouldn't be opposed to working out something, revising the language for that particular recommendation based on these type of considerations. And so the proposed development agreement, LDR 1702, addresses the second phase, and the varying facilities and specifics of how that phase will be developed, how the roads will be constructed, design standards, that kind of thing. So back to our current history of the current application. On March 6th, the development agreement was heard by the Planning and Zoning Board. After lengthy discussion, the board did vote to recommend for approval to the City Commission 4-1. The dissenting vote was former Mayor Conrad, who was concerned that we had not heard from Miriam Steinberg as yet. We had done all of the required public notifications, the signage, mail-outs to a 1,000-foot radius around the proposed development, and advertised it in the newspaper. I had not heard back. During, so then we set the first reading for the development agreement as the March 27th meeting of the City Commission. Prior to the March 27th meeting, in addition to the required public notices for that hearing, we also emailed a packet, and I was able to reach Ms. Steinberg by phone prior to that hearing and discuss the application with her at that time. She requested that we have a meeting with her and her attorney, so then on March 24th, we met at the Little Red Schoolhouse with city staff, city attorney, and Ms. Steinberg and her attorney. We had a follow-up meeting on the 27th, just prior to the City Commission hearing, where once again staff and city attorney met with Ms. Steinberg and her attorney, and they expressed her desire not to be a part of Dillon's Grove at all moving forward. At the March 27th hearing, the proposed development agreement was presented to City Commission for consideration. Testimony was given by Attorney Boyce, by Stuart Cullen, the engineer for the applicant, as well as a staff report. And then when it was opened up to public comment, Ms. Steinberg's attorney also spoke and handed out a memo expressing her concerns and desires not to be a part of the Dillon's Grove development in the future, and pointed out items. And a copy of that memo and staff's response to the specific items that were listed is in your meeting packet. Staff report was presented recommending approval for the proposed development agreement, and as I said, Attorney Ireland distributed a copy of the memo to the Commission and the Mayor.
And
Based
Bryan,
on-
it was
sorry.
at that meeting that we decided, in order to address her and give her a chance to catch up, that's why we're here at this special meeting tonight. So
Yes, sir.
The other party was given an additional 30 days to get up to speed and to come here to present their side tonight.
Yes, sir. At that meeting, it was decided to table the discussion to a future meeting, which is tonight, to give Attorney Ireland additional time. Ms. Steinberg also obtained the services of an additional attorney, which we've also provided information for. They made a public records request, which we basically handed over all the records we had relative to the Dillon's Grove Phase 2 application, including all the emails. And so there has been a lot of information provided, and they were also provided with copies of tonight's staff report and agenda packet in advance of the hearing. So moving on to the comments and recommendations, staff contends that the development, the entire original 352.7 acres, which is Dillon's Grove, remains under the governance of Ordinance 30-02 and the original development order 02-1 and the preliminary master plan. We do not believe that the remaining parcels could be developed as independent PRRDs, as was suggested by Ms. Steinberg's attorney during discussions, because the entire PRRD is relative to a single development. It doesn't have to be in single ownership, as was pointed out. And we do believe, based on the analysis provided by the applicant, that the property that was awarded to Michael Steinberg in the final judgment for the dissolution of marriage does have a somewhat higher density, allowable density of development than the property that was awarded to Miriam Steinberg, just by virtue of the layout of the existing parcels that were used to distribute the property. And
But approving, I'm sorry to interrupt, but approving this tonight doesn't compel her to develop her property and join Dillon Grove. She
No, sir.
doesn't have to develop it, so
she can.
she just has to develop Dillon's Grove if she wants to develop it, but she's not being forced
Correct.
to now develop the property.
Yes, Mr. Mayor. If she chooses not to ever develop, then it sits in agricultural use, whatever a permissible use under agriculture would be. If she chooses to develop, then it would be under the guidelines provided for the PRRD for Dillon's Grove.
The land development regulations specifically encompass the concept that the landowner could bank his or her land in silvicultural pursuits, graze cattle on the land. It can be used for rural purposes. That's specifically addressed in our land development code, is it not?
It is. Each, as in all of our zoning districts, each phase is to be developed such that failure to develop successive phases would not have a negative impact on the phases that preceded it. However, with a PRRD, it's allowed to remain in agricultural uses indefinitely.
Okay.
And just to be clear, one of the reasons that the importance of that undeveloped area is such that once it only makes sense that if you're going to have an undeveloped set-aside for future higher density development, that you're going to concentrate that into a single area, which is what happened with Dillon's Grove. And as a result, each of the residential phases that precede that fourth undeveloped area are going to be at a higher density than 1 per 5 acres, by the very virtue of the fact that you've taken that and that undeveloped area and concentrated it outside of the phases where the other residential is developed. And so once you have a phase on the ground, the wheels are set in motion, and you can't undo the PRRD and then say, well, we're just gonna allow you to do 1 to 5 acres with your parcels and 1 to 5 acres, because you could never go back and establish a 1 to 5 acre, 1 unit to 5 acre ratio with the development,
Sure.
the phases that are already in existence.
Okay.
So.
Thank you, Mr. Thomas. That wrap up staff's comments?
One last thing, and so basically staff recommends approval with the conditions outlined in the staff report, which, do we want to read those into record, or?
Mr. Attorney? Yes.
Okay. Number 1, strike the word successor from the title of the proposed Phase 2 development agreement. Strike paragraph 2, subparagraph B from the agreement. Amend paragraph 3, sentence 6 to read, roads that will eventually continue into future phases shall be paved to the boundary of such future phases to facilitate future improvements. Number 4, under the heading specific design standards, amend paragraph 6 to read, all stub streets shall terminate in a paved cul-de-sac. And number 5, Michael Steinberg shall make application to annex the right-of-way that provides connectivity between the two primary parcels in the proposed Phase 2. Actually, staff wishes to amend that one to say, remove the application to annex, but just simply to annex, because application alone wouldn't actually be sufficient. And on that note, that little triangular corner, as difficult as Alachua County can be with annexation processes, as we've witnessed in the past, this should be a very simple one. It's a small parcel. It doesn't create an enclave. It's got full contiguity with the city of Newberry. It should be a very easy no-brainer for the county.
Is that all of
That's it,
staff's
sir. Yes, sir.
strikings? Does the commission have any questions for staff? I do. Commissioner Farnsworth and then Commissioner Glanzer.
It was my understanding that we're going to be trying to do multi-use land development for future developments. Does this incorporate that?
No, sir, this is strictly residential only. The other categories like planned development can incorporate commercial and mixed use, but this particular development did not contemplate having any sort of mixed use.
Was that contemplated or discussed at any point in time whenever they came back to have this redone?
When I researched Dillon's Grove long precedes my tenure with the city, but when I went back in the record and I started researching the origins of Dillon's Grove, there did seem to be some discussion about a potential for some commercial development, but it didn't appear that it was ever pursued. When the actual application was presented, it was strictly for residential. But for this one, no mention of commercial development was original. Now but you do bring up a good point. In the future, when water and sewer, municipal water and sewer services are available to this area, that land bank area could conceivably be used for commercial. It's not restricted to residential, so it could be a mix of residential and commercial. It could be just commercial. And there is some potential there for the future in that undeveloped land bank.
My other question is, with the roads being laid out as they are currently proposed, does Ms. Steinberg have any say in that? If she decide to develop her property later on? Or, I mean, the roads would be pretty much set as far as ingress and regress is concerned?
One of the requirements that we made of the applicant was that he maintained the connectivity in the same points that were in the preliminary master plan. And so the application before you does that, again, for that one particular area, because there would be additional connectivity from two different points, that area may be superfluous at this point. We don't need it, but it's still presented there to provide Ms. Steinberg with that original envisioned connectivity in the preliminary master plan.
So for instance, if, as the applicant says, look, we'll bond that off, we'll give you a surety bond that if in the event that property is ever developed, and let's fast forward 10 years from now, and whoever owns the Miriam Steinberg parcel, if it's Miriam Steinberg or if it's some other future property owner, says, look, we don't need that midpoint of connectivity. We're going to go with the 2 points on the north side and the south side, and it's bonded off such that we know if it's going to be required, then it will be built by virtue of the bond. But for whatever reason, if Ms. Steinberg says that midpoint connection isn't necessary, and I can configure my lots on my development in such a way that I don't need or I don't want that connectivity on that midpoint, then we release the bond and we say, okay, we're not going to ever use that, and so then we release that. Now, I think the point that we have to adhere to now, though, is that as Mr. Steinberg develops, he can't build over that. In other words, he can't put a residence on that lot, on that midpoint connection, and eradicate the connectivity. So there's a internal connectivity requirement and an external concurrence. It has to be developed concurrent with the use in all phases, such that, and I think the application that's before you in the plan that Stuart Cullen provided allows for that. So I think that the idea of bonding, and of course our manager has a lot more experience with actual paving than I do, but there is some merit to the thought that we have a road in place and it sits there for years and is not used, and it deteriorates. That doesn't advantage the homeowners. And if we have a legal requirement that it will be built at some point, there's a responsibility for the building of that roadway through some legal mechanism, the bond, then that may very well meet our, and we'll certainly discuss those options by our next hearing on this matter.
Now, the bond, is there any time limit on that bond? That has
No,
to
it would
used?
be, it would be until such time as the requirement is for the paving of the road system.
So, I mean, it could be 50 years or whatever?
It's going to have to be in existence until there's a determination on on the Miriam Steinberg property that we're not going to connect, we're not going to use it for whatever reason. So yes, it would be until such time as it's needed.
Commissioner Glanzer?
It may have no bearing on our decision, but did I hear you say she doesn't want to be a part of Dillon's Grove?
That was.
And my
yes, ma'am.
question is like, what does she want from us? What is our decision here? How does that affect her if she doesn't want to be in it? When she says
That was her initial response. Quite honestly, without her appearing tonight, we don't know what her position is right now. Initially, when we were first discussing it, she was of the mindset that the dissolution of marriage had severed Dillon's Grove and basically voided it. And in the intervening weeks that we've had discussions and provided information and such, I think that there's a high probability that she's realized that she is in fact governed by the same rules for development of her property. And that may be why she's not here. That's speculation. But initially, because she was of the belief that she no longer had to participate in Dillon's Grove, she didn't want any part of it. As
and
it stands now,
she thought maybe she could make it a separate subdivision, or or develop it on her own. Is that
Theoretically,
what?
she could
But she can't.
try that.
Yeah.
That would be one thing that Miriam Steinberg could do. She could petition to rezone the property. She could do there's a plethora of things that she could do. She could just leave it in ag use right now and just sit on it. For
But in
years.
2002, when we approved that PRRD, she can't, take that out. I mean, she can just not use it, but
Therein
she
lies
can't
the
change
problem.
she
That's-
can't.
that's
We're
right.
obligated by that. Not by who owns it.
So your point is a good one. If you had a zoning application before you, that would be the issue that you would have to address. How do you accommodate the open space that you've approved for phase 1, phase 2? For instance, you need a 1 to 5 density, and you've got 78 acres in phase 1. Well, what do you do with the 12 acres? What happens to that? It doesn't just disappear. You have to accommodate for that, and that's the decision that was made when you originally permitted phase 1, and that's a benefit and a burden that Michael Steinberg had and Miriam Steinberg the minute that you platted phase 1 with less than 1 to 5 acres, meaning that there was going to be a bank of 12 acres. Now, what do you do with those 12 acres? Does now somehow Michael Steinberg have to eat that 12 acres, so to speak, on his phase, what is now being called phase 2? Does it go to Miriam Steinberg, or does it go in accordance with the original concept that was back in 2002? Well, what you're doing here tonight, what Stuart Cullen has done in his laborious work that he's accommodated, and Dr. Depew has stated that you go back to your original 2002 concept, and that's what you're applying here this evening.
And just because they divorced 11 years later, or whatever it was, 9 years later, that has nothing to do with what we have to decide. I mean, it's irrelevant in a way, isn't it? We still are bound by what we approved in 2002.
Judge
I'm just trying to-
Monaco simply divided ownership
Right.
interest along tax parcel lines. He had no power. Respectfully, he did not have the power over this city commission to change zoning.
Right.
He did not have that ability to do that. So the development order stays in place, and this body has authority over that development order. That's your purview.
And there's nothing we have done or are doing that would restrict Mrs. Steinberg's ability to develop her Phase 4 at some point, what was Phase 4 at some point, so
According
We're
to
not-
Stuart Cullen, you are not burdening her property
that's what I wanted to
any more or any less than it was, or the rights and obligations that were in existence when the development order was created, the preliminary master plan was submitted, and Phase 1 was platted, are the same back in 2002 as they exist today.
Thank you.
And Scott, just to be clear, the question before us tonight, and so that we don't get confused, is does this development sitting in front of us meet our regulations and fit the definition of a minor change? That's really all that we are discussing tonight, not any hypothetical what could or might or happen with later future phases with other owners. It's just whether or not what's in front of us right now fits our regulations and meets the definition of a minor change.
That's the
Is that a
criteria.
fair
That's the criteria.
comment? All right, does anybody else have any questions for staff? Hearing none, does the applicant wish to rebut any of the testimony given against the applicant? Anything in the staff report?
No, we rest.
Okay. I will now open the floor to public comment, each presentation being limited to 5 minutes. Is there anyone in the audience who'd like to take advantage of that? Seeing none, would the applicant like to take advantage of closing comments? Hearing none, the public hearing will be closed, and the commission will now enter into deliberations. Does any commissioner have any final comments?
Sound like a judge.
Any final comments that they would like to make into the record? Hearing none, then I will entertain a motion at this time.
I move to approve the application with the revisions outlined by the city staff.
I have a motion from Commissioner Farnsworth and a second from Commissioner Coleman. Are there any last questions or comments from the commission?
These are the conditions associated with staff report. And for the record, the staff report has been also tendered to our clerk along with the overhead projections by Dr. Depew and the overhead projection by Bryan Thomas.
Okay.
So all of that will become
Will
part of the
become
record.
part of the record. Thank you. Okay, I have a motion and a second. No further comments. All those in favor signify by saying aye.
Aye.
Passes unanimously. Anyone have any last things to say? Meeting adjourned.